I want to introduce you to a well-educated man who went to prison. We're going to hear about why he went to prison and what he did while he was in prison. David, thanks so much for being on the program. Tell us a little bit about your background before we get into your prison experience.
Thank you, Michael. Pleasure to be here. I was a practicing and licensed attorney in the state of Illinois for almost 15 years prior to becoming a management member of a startup biotech company in the Chicago area. And that ultimately led me to prison, where I was convicted in the early 2000s of a white-collar crime of wire and mail fraud.
Let's talk about that for a second, because people might have some level of, that doesn't seem congruent. You're an attorney. You later became a CEO, and yet you found yourself in the crosshairs of prosecutors. Tell us a little bit about what it felt like to learn that the Department of Justice was targeting you for prosecution.
The case ultimately began as a Securities and Exchange Commission civil case, and there was a referral, as I understood it, made to the U.S. Attorney's Office in the Northern District of Illinois.
How long did that take? You found out that there was a SEC investigation, and was there actually a finding in the Securities and Exchange Commission investigation?
No, actually, the SEC investigation began in early 2002, and the SEC ultimately did not come to a conclusion in that case until after the criminal case was resolved. It was actually put on hold during the pendency of the criminal case.
So the cases were going simultaneously. First, there was a Securities Exchange Commission case, then that was put on hold, and the DOJ picked it up. Is that right?
That's correct.
And when you found out that you were a target of criminal charges, what did you do? Did you agree to cooperate, or did you go to trial, or did you plead guilty? What did you do?
Well, when I first found out I was a target was during a raid of our corporate facilities, and I wasn't told I was a target, but it was basically a common sense conclusion. I hired an attorney at that time, and the case ultimately was not prosecuted, or the initiation of the prosecution didn't begin for another 2 to 3 years. So there was a long period of time that I remained the CEO of the company and chairman of the board, but then ultimately I relinquished those positions. Others came involved, and
tell us about that. That's interesting. So the Department of Justice raided your facility. Then there was a 2 or 3 year period before you were charged. Is that what I understood you to say?
That's correct.
And were you operating in the capacity as if this was going to be, you were going to be exonerated from that raid, or were you concerned that there could possibly be criminal implications?
I was quite concerned there was likely to be criminal repercussions. The problem was that if the company shut its doors at that point, there certainly would have been, in my view, criminal repercussions. So I continued as I was.
So you continued, and then ultimately they returned an indictment. Did they arrest you, or did they just serve you?
I was never arrested. I had counsel at that point who the U.S. attorney was familiar with. So it was a no cash self-recognizance bond scenario where I simply appeared for my arraignment.
And you appeared for your arraignment, and then how did it ultimately end up with regard to the adjudication of that case? Did you plead guilty, or did you go to trial?
I ultimately pled guilty approximately 2 years later.
What was the cost of litigating that case? Do you recall, David?
I believe it was $25,000.
So not a tremendous amount of legal fees at that time. Were you happy with the representation you received?
Yes.
And you ultimately agreed to plead guilty to a sentence of how long?
14 years. Well, let me backtrack. I did not agree to a fixed term of incarceration. We simply agreed to plead guilty without a determination or agreement on the loss figure, which is the large driver of the sentence ultimately in these mail fraud, wire fraud cases. My responsibility for a particular loss figure. So because that was left open, I didn't agree to an amount of years. That was never.
What were you anticipating with regard to a sentence when you agreed to take the plea agreement?
In the area of 10 years. It was. I was told by my counsels at that point, because I also had sentencing specialist in sentencing at that point, that they were confident that I would be able to get to a minimum security camp initially. That did not occur.
So you thought that you would get 10 years. Had you not gone Had you not accepted that plea agreement, what was the threat of sentence length?
Well, given at that time, as you may recall, you had several very high-profile white-collar crime cases, including the Madoff case. So I was very concerned that if I were to go to trial and lose, which I thought was almost a certainty, that I would be sentenced to 20 to 25 years. That was a very significant likelihood, at least 20, and I wasn't willing to live with that.
So you agreed to take the plea agreement, anticipating that you would get 10. And what was your reaction when the judge handed down a sentence of much longer than 10?
Very disappointed. My attorneys and family were very, very disappointed. I wouldn't say I was shocked because, of course, 14 years is far greater than 10. And yet, when you're involved in these cases, as I soon became involved with in prison on a regular basis, what you find is the amount of years are given out by these judges, so freely and so comfortably by them, that it's hardly surprising that I did get to 14.
And how old were you when the sentence came down?
47 years old.
And you went into the prison system at 47 years old with a 14-year sentence. Where did you begin?
I began at FCI Loretto in Pennsylvania, far from home. That's another question that's often asked of me. Why would they send you so far from home? But what you learn in this system is I'm sure you have found yourself, is that oftentimes it's just by chance that it's wherever a bed is available. There isn't a lot of thought that goes into it. But I began at FCI Loretto, was there for a year and a half until I was camp eligible.
And how long did it take you to transfer to the camp from a year after you were there? Did you go right after a year and a half?
I immediately. That actually worked out very well. I was processed very quickly. I had a very, very amenable case manager and counselor. That worked out very well.
So you started inside of a low security prison in Laredo, is that right?
Loretto, Pennsylvania.
And what was the population level there? Was it more than 1,000 people?
1,400 inmates.
And how was your initial adjustment inside of a low security prison?
Very, very good. And the reason why actually is because when the inmates found out that I was an attorney on the outside, I was very busy right away assisting inmates. And that happened within the first 2 weeks. So from, I would say, the 2-week period onward for the year and a half, I was literally busy 8 to 9 hours a day.
What kind of practice did you have prior to going to the prison system?
A civil litigation and bankruptcy practice, corporate bankruptcy, representing trustees in bankruptcy, and civil, both state and federal litigation. I was a member of the federal trial bar in the Northern District of Illinois for many years.
And what was the learning curve to transition from civil litigation and corporate governance to prosecuting habeas corpus petitions, post-conviction litigation in prison?
It was an adjustment, but surprisingly not significant or as significant as one might expect, because the general guidelines for what litigators learn to become a civil litigator apply in the federal context and in the criminal context. So the transition was more or less just studying the federal criminal statutes. And that came fairly quickly because, again, I was so busy right off the bat that I was immersed in these statutes from the first few weeks. And basically, what one learns when they do this kind of work is that much of the work, particularly as a jailhouse lawyer, and that's what we're called when we're doing the work within the prison, is done with a number of forms, and you're using these forms repeatedly. So it's something that became very comfortable for me.
And you're talking about forms primarily 2255s and Bivens actions and that kind of thing, or is there something else?
And 2241s, yes.
So why don't you help our audience understand the difference between a 2255 and a 2241?
Generally speaking, a 2255 habeas petition is used when one is contesting the validity of their sentence or conviction, the underlying case, if you will. On the other hand, or by contrast, a 2241 habeas petition is typically pursued by an inmate who has complaints about prison conditions. The most common, typically being in my experience, lack of appropriate medical care. That was probably the single most common issue that I was dealing with in the 2241 context. Although now, as I've been filing of late, and in combination with compassionate release motions, which we could discuss in a minute, the 2241 petition also applies to this COVID issue at present.
Why don't you help our audience understand or differentiate between a 2255 petition and a direct appeal?
A direct appeal is a precursor or it has to be the first step a litigant or a defendant takes prior to filing a 2255 motion. Ultimately, they serve the same purpose, but after one is convicted, the first appellate line of attack is a direct appeal. And I would add, by the way, that I did a lot of direct appeal work too, primarily being the voice of the inmate in prison to their assigned or appointed appellate counsel. So I assisted a lot in that context. But what happens is you first need to exhaust your direct appeal avenues of attack before you file the subsequent 2255 habeas, which is basically the last attempt you can make attacking your conviction.
And can you help the audience understand a little bit about the burden that a pro se inmate has to overcome with regard to prevailing on an issue such as ineffective assistance of counsel?
Very, very challenging. In fact, it's a funny story because I was very busy, as I mentioned to you, in these prisons because I wasn't a guy I wasn't doing it for the money. I was many times getting, paid a cup of coffee. But what I would tell everyone in prison was that, and it would be to the chagrin of many of the jailhouse lawyer competitors of mine because they were looking to charge real money, is the percentage of success on those type of appeals is no more than 1 or 2%. It's very, very rare that a person has success on these appeals. And when we define success, unlike the typical success definition of a jailhouse lawyer who will say, when we get you back into court and you have an evidentiary hearing, that's defined as a success. A success is either at the end of the appeal, after all the appellate avenues have been pursued by both the government and the defendant, there is either a shortening of the sentence or there is a release of the defendant. That is how a success, from my perspective, is defined. So very, very rarely do you see successes.
And you said that you did 11 years. How many 2255 petitions would you say that you prepared?
Well over 100.
And out of the 100, are we to understand then that only 1 or 2 got relief?
I had 2 successes.
Out of 100.
Those were shortened sentences.
Okay.
Were not releases.
And let's talk about a 2241. What is the level of your experiences, which is different because on a 2241, as you said, you're challenging the conditions of confinement. Let's start with the administrative remedy process and what relationship that has to a 2241.
In order to file a 2241, or as we can speak about in a moment, a compassionate release motion, there are requirements to exhaust what is called internal administrative remedies. An internal administrative remedy is filed through the prison itself by the inmate through a series of forms that are submitted to a variety of levels in the Bureau of Prison process. First, there is a filing with the case manager and counselor, followed by a filing with the warden, followed by, if necessary, a filing with the regional office for the Federal Bureau of Prisons, and finally, with an attorney for the central office of the Federal Bureau of Prisons in Washington, D.C. And that process typically takes 3 to 4 months to play out.
So after those 3 to 4 months, what rights does the person have to begin the 2241 motion?
Following exhaustion, which is defined as a conclusion against the inmate by the attorney for the central office, the inmate can move immediately then to file the habeas corpus petition pursuant to 18 U.S.C. section 2241. What is
the experience that you have had in prevailing on administrative remedy?
Very rare. Once again, only in the context really of medical issues where there's an agreement typically to send out an inmate for private consultation with a private physician outside of the prison. That would be my typical request, where the inmate felt he wasn't getting a fair shake, if you will, with the health services department in the prison and wanted to get a professional opinion from outside the prison. I had several successes in that vein. But then, even only then, when this medical condition was very serious.
And when a person has other issues in the prison other than constitutional violations, but let's say he's he is being harassed by staff members, or he is just being discriminated against, or his civil rights are being violated, what is the appropriate vehicle or mechanism for that person to bring his grievance?
Well, and specifically when you refer to civil rights violations, and you refer to this phrase earlier, a Bivens action, which is the equivalent of a civil action in the federal context to contest actions that the inmate believes are unlawful, and it's typically in the context of prejudice, claims of prejudice in the prison context, based upon faith, based upon race. These are typical issues that are brought in a Bivens action. And I did file many of those too through the years.
And am I correct that the appropriate remedy request or request for relief is monetary damages?
That's correct.
And what about
as opposed to the 2241 context, where you're asking for basically what is called injunctive relief, action being taken on behalf of the inmate in favor of the inmate, as opposed to monetary relief.
Prior to the passage of the First Step Act, the compassionate relief was limited to being at the request of the director of the Bureau of Prisons through a series of channels up the chain of command, from warden to regional director to director. But the First Step Act changed that. And so it's my understanding that a person, an incarcerated person, can now file his own request for compassionate release. Could you tell us a little bit about what requirements he must overcome in order to file that motion?
Well, unlike the full scope of the administrative remedy process that I just referred to, in the context of the what's called a 3582, which is the statutory number for a compassionate release motion, one must, or the inmate must, first file a formal request to the warden of his prison for compassionate release. And there's certain requirements that one must meet, which typically involves a serving of over 50% of his sentence, being over 60 years old in age, and having what are considered to be serious and potentially life-threatening medical conditions. So it's still a challenging situation, but one must, before they file that compassionate release motion, both file with the warden and then wait an additional 30 days from a denial by the warden to file the compassionate release motion. I want to say one more thing, Michael. That filing of the compassionate release motion is filed in one's sentencing court, as opposed to in the 2241 context, in the district court closest to where the inmate is housed at that time.
And that would be the same for a 2255. That is also filed in the sentencing court. Is that correct?
That is correct.
So recently, the coronavirus threat has opened the floodgates of filings for 3582s. Could you tell us a little bit about your experience in filing those kinds of motions?
A 3582 motion, and the challenge of it I'm finding in the COVID context thus far, is that the purpose or the primary basis for Congress's enactment of that statute is to focus upon the elderly inmate, as I mentioned, who has significant health issues and has served a significant portion of their sentence. By contrast, what I have found, and we're finding this more and more, many of the inmates who have medical conditions that compromise their immune system, which is Attorney General Barr's basic standard for appropriate review of those inmates for release given COVID, many times have just either entered the prison system or have certainly served far less than 50% of their sentence, and are oftentimes a far younger age. So it's very tricky to satisfy what it was the initial purpose and rationale in bringing the compassionate release statute to bear in the context of COVID. There are advantages, though, which I could discuss in a moment about, and from my point of view, still, though, in certain instances in bringing a 3582 compassionate release motion in the context of the COVID issue as compared with the 2241 petition. Although I would say that in this day and age, it's good to exhaust all of your options and file all of them, because you are filing in different courts.
We have spoken in the past about the urgency of COVID and the fact that people are dying, and the fact that people in prison cannot practice the guidelines established by the CDC or even by the president. In those types of circumstances, how are there strategies of getting around, or at least attempting to get around, that requirement for the administrative remedy exhaustion?
I'm finding it quite challenging. There is a body of law, and I've been citing it, that in emergency situations, particularly those involving medical issues such as the COVID current situation, where there's an emergent situation medically, that the court has it within its discretion the ability, and has done so on many historical occasions, to waive the exhaustion requirement. Unfortunately, what I have found recently in two courts in particular, in filings I've recently made, is that these judges are reticent to, and have actually made a recommendation to deny the petition without prejudice, meaning that the inmate can refile once he fully exhausts. But I would say to you that in those contexts, in these particular contexts, there were no prisoners at those prisons where there were active cases of COVID. So I think the conclusion was probably more focused upon the fact that there was no emergency situation by virtue of the fact that there were no active cases.
As somebody who served 26 years, my position has always been that you've got to fight and you've got to try. And even though the odds are difficult in a time like this, a person has to try. What thoughts do you have on that front? Are you seeing anybody getting relief anywhere around the country?
Interestingly, Michael, I've seen very recently a number of inmates who I've been speaking to who have received who have contacts in the prison. They have not received, I should backtrack, have contacts of theirs in the prisons who have received relief through the Attorney General Barr pronouncement that these inmates should approach their case managers and wardens and formally request compassionate release. Many of these inmates who otherwise meet the compassionate release requirements in terms of age, amount of time they've done in prison, and importantly, have medical conditions where these particular prisons also have infectivity of COVID cases. There are instances that I'm seeing where there is success with certain of these inmates going into home confinement. I think that should be the first approach for people who meet the requirements of compassionate release, is to first go through the prison process.
I'm going to try and pull up a screen share with you, because I want to show you a declaration from the warden, an associate warden at the federal prison in Louisiana, who spoke about 5 people in his prison that did file the 3582 and did, oh shoot, I'm not going to be able to do that right now. Apparently I'll share it later. But there is an associate warden in Louisiana, Oakdale, who actually filed an affidavit in response to a COVID case, and he spoke about 5 people in his institution that were successful in getting out. And he didn't make mention of their age, but that's something that you've mentioned a couple of times tonight. So are you finding that if somebody is not 60 years old, is somebody is younger than that, is able to get relief, or should they not even try?
Well, no, let me clarify. The 2 people that I spoke to in the last 2 days that I believed had a very good chance and had met all the requirements, but had not yet served 50% of their sentence, were denied on that basis. Attorney General Barr very recently, in the last day or two, actually came in with this strong pronouncement that nobody who has not served 50% or more would receive the compassionate release through the internal BOP process.
And how about through the judicial process?
Well, again, Attorney General Barr's pronouncement is a guiding force to the Federal Bureau of Prisons. It is not precedential in terms of what a judge can decide. So that isn't part of the law vis-a-vis the 3582.
So we have seen judges that have actually given relief to people in prison, even though they don't meet the guidelines that the Bureau of Prison indicates. Is that right?
That's correct.
And so if I were in prison, would you advise, if you had a son in prison, would you be advising your son to listen to the Bureau of Prisons and not do anything? Or should he at least try to get into court?
I think my view is, and I think I mentioned this earlier, if I didn't, let me make it clear, is if I had a son, I would encourage him to exhaust all opportunities for success, which would include in this instance, pursuing the internal process that we refer to, but only if you meet those requirements. If you clearly don't meet those requirements, it doesn't make any sense even to pursue the internal process. For instance, if you haven't served 50%, if you just entered prison, you don't have any medical conditions, and there are no cases in the prison, I wouldn't waste a lot of time with the internal process. If you meet one or more of the...
Right there. Let's just continue right there. You wouldn't waste time trying to lobby through that Bureau of Prisons. Does that mean you would then turn your attention to going to federal court, or you would just not do anything?
It would depend on how many other factors you have working in your favor. I was about to say, if you have one or more working in your favor, either a medical condition compromising one's immune system, you are of an elderly age, and or you've served 50% of more of your time, one or more of those conditions, I would pursue both the compassionate release and the 2241 approaches, once again, because they're filed in two different courts.
How about a case like Michael Avenatti, who is, you're familiar with that case?
Yes, I am. And Michael Cohn as well.
And neither of those people are 60 years old, and neither of those people serve 50% of their time. Both of them are going to home confinement.
Very interesting. I was very surprised.
But so what I would find in that is that if you don't try, nothing happens. If you try, the odds may be 1%, but you're trying.
That's true. Yeah, that is very true.
And so, I don't know that the right answer. I think every answer has to be on an individual basis, but it sure is helpful to know that people have a resource like you that they can ask these kinds of questions. And we did receive a question from a young woman who's advocating on behalf of her son. She asked, how long would it take you to prepare documents that would help her son or potentially help her son?
I have prepared a detailed process sheet, which involves is basically a detailed questionnaire, the answers to which provide me with the information in full that I will need to file both a 2241 petition and a compassionate release motion. From the moment I receive those answers in full on that process sheet, I can file within 1 day. Now, that doesn't mean we will, because the process is I will send the documents to the client for review, and the client ultimately will send in the documents, but the documents will be ready for filing within 24 hours. All of the templates for these have been created. I've done a number of these cases in the last several weeks, and at this point, what changes the document are the specific answers to the questions that we've created in the process sheet.
Well, that's very helpful. I'm sure that'll be very helpful for any listener. And if anybody wants to get a hold of David, I will be very happy to pass along his contact information. And David, we'd love to just, have an ongoing dialogue with you on matters related to, what your experiences were while going through 11 years in prison. And I want to just thank you for giving us your time this evening. Is there anything you'd like to say to the group?
Well, I'd like to also say to the group that I'd like to be back and also keep you all apprised of developments as I hear them from inside the prisons from my current clients who are reporting to me on a regular basis, particularly on this COVID situation, which is so fluid. There is a lot of very interesting, I would say, but oftentimes disturbing information I'm getting back from the inmates, insofar as the lack of testing for staff in particular. And those staff who are many times asymptomatic are likely to be bringing in many instances, the COVID virus to the inmate population. So that's very, very concerning, and it continues on an ongoing basis today.
So the name of our group is Prison Professors, and David clearly is somebody who has gone through 11 years plus in prison, is eminently qualified as a prison professor, and just want to make it clear that our role is to help people understand what strategies that they can pursue, but at the end of the day, it's their choice on whether to pursue it or not. My experience of going through 26 years in prison was always to be a self-advocate and to try and get the best possible outcome. David, I trust that you feel the same way.
I do, Michael, and I appreciate the opportunity to speak to you and your listeners this evening.
Excellent. So his name is David. He's part of the Prison Professors team. And if you want to connect with David, please let us know. I'm sure that Justin can connect you, and you'll have an opportunity to learn from somebody who's got an immense amount of knowledge, both about the prison system and about post-conviction opportunities. And as you can see, he's very open and transparent and happy to share with you what he's learned. Thank you.
Thank you too.